They say the two happiest days in a boat owner's life are the day they buy the yacht and the day they sell it. But these days, the happiest people at sea aren't buying yachts, they're chartering them. And if you've spent any time in places like Saint-Tropez, Capri, or the Dalmatian coast, you've probably noticed wealthy Americans are flocking to Europe's waters like never before. But here's what most people don't realize. While chartering a yacht in Europe can be one of the most luxurious experiences money can buy, it can also become a legal and financial disaster if you don't know what you're doing. You wouldn't sign a 7-figure business deal without a lawyer, so why would you sign a 6-figure charter agreement without one? I'm Santiago Cueto, board certified in international business law and best-selling author. And today I want to give you a peek behind the curtain of European yacht charters, what the brokers won't tell you, what the contracts are hiding, and what you need to know before stepping foot on board. Let's start with the basics. Most yacht charter contracts in Europe are governed by foreign law. That might be English law, French law, or even Italian law, depending on where your yacht is registered and where you're setting sail. If something goes wrong, and trust me, it happens more often than most people admit, you might be forced to resolve the issue in a court thousands of miles away, under rules completely unfamiliar to you. Then there's the issue of taxes. In the US, we're used to seeing taxes tacked on at checkout. In Europe, the value-added tax, or VAT, is often buried in the contract terms. It's not unusual for a client to agree to a £250,000 charter and then be hit with a surprise 20% VAT charge. If your contract doesn't clearly state whether VAT is included, you could be left footing the bill long after the champagne's gone flat. And of course, there's the MYBA contract. That's the Mediterranean Yacht Brokers Association standard agreement, basically the go-to charter contract in Europe. It's widely used, well-respected, and sounds fair enough on the surface. But here's the catch. It wasn't written with your interest in mind. It's a broker's document, and unless you go line by line, checking the cancellation policy, understanding the refund rules, and making sure you know what happens if the yacht breaks down, you're just simply rolling the dice. Let me give you a real-world example. A client of mine, a tech executive from California, chartered a 150-foot super yacht to cruise into the French Riviera. Picture it, a week of private coves, rosé on the sun deck, and lunches in Cannes. Everything was perfect, until the yacht developed engine trouble 2 days into the trip and had to remain docked in Saint-Tropez. No cruising, no Amalfi Coast, just sitting in port. Naturally, he asked for a refund, but the contract had a clause, one line, buried halfway through, that limited the owner's liability unless the yacht was completely inoperable for more than 48 hours. And sitting in a marina with working air conditioning and champagne flowing technically didn't count. The yacht hadn't been delivered defective under the legal definition, so no refund. He was stuck at the dock watching other yachts sail by, out $300,000, and the only way to recover his money would have been to file suit in Monaco under Monegasque law. This process would have taken years and cost more than he stood to recover. This is exactly why these contracts aren't just boring paperwork. They are your shield. Another hidden pitfall, the APA, the Advanced Provisioning Allowance. This is the deposit you pay up front, things like fuel, food, docking fees, and tips. But if the captain overspends, or if you simply misunderstand what's included, you're responsible for the overage. I've had clients tell me they felt like they were being billed twice for the same trip, and in some cases they were. But by the time they came to me, the contract was already signed and the yacht was halfway to Corsica. That's why I always tell clients, have someone experienced review the contract before you board the yacht. Don't rely on your broker to flag the fine print. They're incentivized to close the deal, not protect you from legal exposure. And while we're on exposure, don't assume your valuables or your guests are automatically covered. You may bring your watch collection, your drone for filming, even a private chef, but unless those details and the liability for each are clearly addressed in the contract and covered by the right insurance, you could be one accident away from a legal mess. Look, I'm not here to scare anyone out of chartering. Quite the opposite. I want you to enjoy the experience, to take that once-in-a-lifetime trip and feel fully in control of it. But I've seen far too many smart people get blindsided by terms they never fully read, rules they didn't understand, and jurisdictions they didn't even realize they were subject to. The solution? Simple. Just slow down. Ask questions. Get legal eyes on the agreement. Make sure you know what you're signing and who you're signing it with. Yacht charters are meant to be unforgettable in the best way possible, and with the right legal preparation, they will be.